Major breaking news out of the United States Court of Appeals for the Second Circuit in New York City, a crazy and clearly wrong decision, and you'll see why. Discussing whether or not people can sue judges that are functioning as licensing officials when it comes to the issuance of concealed carry permits. You're not going to believe this craziness out of New York City, but unfortunately you probably will. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. Well, my former boss, Ray Lawyer, is now judge lawyer on the United States Court of Appeals for the Second Circuit. And he has just issued a major ruling against the Second Amendment. I think he got this clearly wrong, and you'll see why. I'm going to explain it. I don't think it was terribly wrong, but yeah, basically wrong. Pretty wrong. You'll see why in a moment. Specifically in this case of Kellogg versus Nichols, and the issue presented in this case of Kellogg versus Nichols is whether or not individuals who have been denied their concealed carry permits, who apply to get a concealed carry permit in New York, and then they sue the judges who were functioning as an administrative officer, like a cop, like a sheriff, like law enforcement, like NYPD, in the determination, in the first instance, mind you, of whether or not a concealed carry permit should be issued. As you know, under New York state law as a general matter, it is unlawful to possess or carry a gun, a handgun. But there's an exception for that. If you get a license to carry your handgun in public, as you know from Bruin at this point, you can carry your handgun in public for self-defense, but you need to get a concealed carry permit. And there's a process for that, much of which is unconstitutional, but that's not the purpose of today's video per se. What happened here is two individuals applied to get a concealed carry permit in Columbia County, New York, and they were denied. Now, the merits of whether or not they should have been denied or not is a separate question, because this decision in Kellogg versus Nichols really turned on a procedural question, but it's very important for our Second Amendment rights. Because in New York, there are two types of people, I would say, that generally are responsible for reading an application for a concealed carry permit and determining whether or not the statutory criteria is satisfied that would cause the issuance of the permit to the individuals who can then conceal carry in the state of New York. Now, generally speaking, there are two buckets of individuals that make these determinations, and I'm keeping it general here. Those are law enforcement officials, sheriffs, NYPD, police stations, whatever it is. And the other bucket consists of state court judges. But whether or not you're looking at a decision by law enforcement or a licensing official or by a state court judge, they are doing the exact same thing. And what is that? It is they are acting as administrators. They are administering the CCW permitting process as required by New York state law. Now, the reason why that background is important, and I'm going to show you exactly how this Second Circuit panel of 3-0 got this wrong. The question presented in this case was whether or not this judge, in particular in Columbia County, who refused to issue the concealed carry permit, whether or not he could be sued and enjoined in various ways under the relevant statute, 42 U.S.C. 1983, which is the sort of judicial tool or the statutory weapon, if you will, that allows people to bring constitutional challenges against state officials. So all these Second Amendment cases that you see brought against officials in a state of Texas or state of New York or whatever, they're technically brought under a process, a statute, 42 U.S.C. section 1983. It's part of the civil rights statutes of the federal law that says if a state or local government official, make a long story short, but if one of them are violating the law, you can sue them under the Constitution for violating constitutional rights, but they use the statute 42 U.S.C. 1983. Now, the reason why that's important is there is a general rule, of course, that you can't sue judges who, as a general matter, have absolute immunity from their judicial function, which makes sense because judges have to make a lot of difficult decisions, and they're always ruling for one party over another party, or vice versa. So as a general matter, you can't sue judges for civil rights violations. But there's an exception to this, an exception. And that exception is if the judges who are functioning as judges in name only are really functioning in a particular instance, not as a judge, but really as like an administrative clerk, acting like a law clerk, acting like a sheriff. They're not functioning as a normal judges. And in this case, that is clearly what was going on here. In fact, you don't have to believe me. There's a decision here by one of the important courts in the state of New York describing how judges, when they act as administrators administering concealed carry licensing permit regimes, meaning whether or not they're allowed to get a gun, allowed to get a concealed carry permit and the like, they are functioning administratively, not as judges. So even though they might wear a black robe and they might be a judge, they're acting as administrators. They're not acting in the traditional role of a judge, which is resolving disputes between multiple parties. And just to give you an example of the kind of precedent that I found, just knowing off the top of my head, that I did not see in the Second Circuit decision, because the Second Circuit decision came out and said in Kellogg versus Nichols that you can't sue judges, even if they're the responsible for denying you a concealed carry permit. You can sue everyone else in the state who denies you a concealed carry permit if they're the decision maker, but you can't sue judges. But that's hooey. Because in this instance, the judges are not acting as judges. They're acting as concealed carry permit administrators. And here's what the case of Guthman said by the New York Appellate Division for the 4th Department. Here's specifically what an appellate court in New York had to say about New York State judges dealing with concealed carry permits and the fact they are indeed not acting as judges in that capacity. They're doing something different. They're administrators. Here's what the case said. It says, quote, Respondent Stephen Guthman appeals from an order that inter alia revoked respondent's pistol license. The appropriate procedure, listen carefully, folks. This is the New York State Court, Appellate Court. The appropriate procedure for the review of a determination of a county court judge acting in their administrative capacity as the firearms licensing officer for the county under the relevant penal law is not a direct appeal, but the commencement of a CPLR Article 78 proceeding in this court. You hear what that court just said? A New York State Appellate Court literally talks about a judge, a county court judge, acting in their administrative capacity as the firearms licensing officer for the county. Literally, New York State courts are describing New York State judges when they sit and decide whether or not to issue a concealed carry license. They're not acting as judges anymore. They're acting as administrative officers like a sheriff or NYPD or other law enforcement person. Therefore, if you can sue a sheriff, if you can sue NYPD, if you can sue law enforcement under 42 U.S.C. 1983, and sue them for violating the Second Amendment, so too can you sue a New York State judge who is acting in his administrative capacity as a concealed carry licensing officer. So says the appellate division in the state of New York that actually oversees these judges. Yet here you have, in the case of Kellogg versus Nichols, the United States Court of Appeals for the Second Circuit, in an opinion written by a judge lawyer, literally explaining that you cannot sue for a Second Amendment violation these judges in the state of New York when they function as overseers of and deciders in whether or not someone gets a CCW license, even though New York State appellate courts literally say that's wrong. Who knows more about New York State law and judges than the judges that actually are in New York State? But the Second Circuit Court of Appeals screwed this up. Now, it's true you cannot sue a judge personally for personal damages. That's a fair point. But this decision by the Second Circuit went beyond that, and it becomes really internally inconsistent. Think about it for a moment. This court went on to say in the Second Circuit to say, look, you cannot seek injunctive relief. You cannot sue the person responsible for the issuing the concealed carry permit when they refuse to give you a concealed carry permit, because the person refusing to give you the concealed carry permit is a judge. But it doesn't matter if they're a judge, if they wear a black robe and call themselves the honorable. It depends on what are they doing? What is the function? And in this case, they're not functioning as a judge. Because what does a judge do? There's a case between Martha and George. And the judge sits there and listens to Martha's arguments, listens to George's arguments, and makes a decision as a judge as to who should win by applying the law to the facts. But here, the judge in this particular county was not presiding over a case between two parties. The judge here was making a decision as a clerk, if you will, of whether or not these individuals should get concealed carry permits. And then is able to say that you can't sue me because I'm a judge, even though I'm acting not as a judge in this case, but as an administrative officer, which is what exactly the appellate division for the 4th Department has to say about this. Now, what's even crazier is this. Let's think about what the Second Circuit says. The Second Circuit decision is essentially saying, if a sheriff refuses to issue a concealed carry permit under New York law, the sheriff can be sued under 42 U.S.C. 1983 for our Second Amendment violation. That's true. That makes sense. But now let's take that logic to the next level. How is it possible that you could sue for violation of the Second Amendment a sheriff for denying a concealed carry permit, but you cannot also sue a judge who is doing the exact same job as the sheriff in assessing whether or not you get your concealed carry permit? The sheriff and the judge in that instance are doing the exact same judge. And the reason why this is an issue is in New York State, some counties want judges to oversee the concealed carry process. And in other counties, they let law enforcement do it. But they're doing the exact same job. And yet the U.S. Court of Appeals for the Second Circuit will allow a Second Amendment lawsuit to be brought against the sheriff or the NYPD for not issuing the concealed carry permit, but they're not allowing it to be brought against the judge acting essentially in the exact same job as the sheriff, which also poses a sort of a corollary ridiculous question that apparently the Second Circuit didn't seem to want to address. And that's this. In addition to the fact that the sheriff who can be sued under the Second Amendment is doing the same job as the judge who cannot be sued under the Second Amendment, according to the Second Circuit decision here, one might also ask is, if the sheriff is deciding on a concealed carry permit and doing the same job as a judge deciding on a concealed carry permit application, then is the sheriff now acting as a judge? Is NYPD in the licensing division there, when they decide whether or not to issue a license for a concealed carry permit, is NYPD now acting as a judge? Crazy, crazy. But that is the decision in Kellogg versus Nichols by the Second Circuit, I'm embarrassed to say. I understand why they said you can't sue the judges personally for money. That makes sense. That's longstanding precedent. That's true. But not allowing these plaintiffs to sue the judge who is functioning as the licensing officer is absurd when you could sue any other licensing officer in the state of New York who's not a judge for the same claims that these people are being denied. And there's no difference between the action of the sheriffs and the judges here. And now, because of the Second Circuit decision, the only difference is you can't bring injunctive relief against the decision by a judge refusing to issue a carry permit, but you can pursue a sheriff or NYPD or other law enforcement agency for a Second Amendment violation for refusing to issue that same permit. And they're doing the same job. It's simply an absurd ruling, in my view, in Kellogg versus Nichols by the Second Circuit today. Now, to sum up, I want to point something else out. This court knew about the points I just made, and they dodged it like little children, in my view. They didn't want to do the hard work. They want to do the sloppy, easy work and just use generic law that says you generally can't sue judges. But there's two additional absurdities by this ruling. One is they tried to draw an analogy to divorce proceedings. You can't sue a judge in a divorce case over New York State divorce law. But that's stupid, That's a stupid analogy. Do you know why? Because again, go back to my point, that in the context of suing over divorce cases, you're dealing with a judge presiding over a wife and a husband getting divorced. Two parties. Obviously, you're judging between the two arguments. Here, the judge is making the decision literally whether or not you get a concealed carry permit. He is the decision maker. And when he does something you disagree with because he denies you the permit, he is the cause of the denial of your Second Amendment rights, allegedly. He is the other side. That's why you get to sue the judge, because he made a decision as the administrative officer to deny you your permit. He is no different than the sheriff that denies you the permit. And you get to sue the sheriff, so you should get to sue the judge who denies you the permit, because he's not adjudicating two parties in front of him. He is the party. And the fact is that this court knows that they dodged this question. All you need to do is look at this opinion. I'll put a link to it below. Take a look at the language in footnote number 2, where they're admitting to what I'm saying is an issue, but they chose not to decide it because they're little school children running away from the hard questions, in my opinion. Take a look at the opinion and tell me if you disagree. That's how I read this together. But here's what footnote number 2 says. Tell me if it sounds familiar. Because Libertarian Party controls our decision under the circumstances of this case, we express no views on whether decisions legislatively entrusted to judges in certain communities and to law enforcement officers in other communities are properly viewed differently depending on the decision maker for the purposes of recognizing whether the officers are entitled to absolute judicial immunity. So there you have it, folks. While they're talking in this context, in that footnote specifically dealing with the question of judicial immunity from money damages, they understand the distinction that I'm making here. That you cannot say that I get to sue a sheriff who makes the decision to deny concealed carry permit, but you can't sue a judge who does the exact same job as that sheriff in the same state of New York. They have to be treated the same. The sheriff that violates Second Amendment rights and the judge that does the same, acting as the licensing official, they're the same. You have to treat them the same. If you can't sue the judge, then you can't sue the sheriff, and that obviously is not the law of America. Nevertheless, the Second Circuit, in my view, screwed this up royally and trying to claim that they had some precedent. Nonsense, because the precedent did not deal with whether or not there was standing to sue the judge that denied you the concealed carry permit, and obviously you should be able to do so. Nevertheless, that's what the decision is. Will there be repercussions from this? Will the state of New York decide that all judges get to decide everything all the time to avoid being sued? That I do not know, but this is the sort of games that we get to see in places like these blue state jurisdictions, and this is a panel that I'm sure knows zero about guns and doesn't seem to care about our Second Amendment rights. So I'm not surprised by this decision, but it's disappointing nonetheless. Anyway, there you have it, folks. Hope you enjoyed today's episode of the Four Boxes Diner. Make sure you subscribe both to YouTube and to Rumble. Make sure you also follow me on X at Four Boxes Diner, and I look forward to talking to you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.